Hello, everyone. Thanks for tuning in. My name is Alex Lucifero. I am an employment lawyer with Samfiru, Tumarkin, LLP. This is the Wednesday afternoon edition of Employment Law Q&A. We've been running these segments now for several weeks, very popular with our viewers and listeners. It's an opportunity to get your employment questions answered. If you're dealing with a difficult situation at work, if your boss is not treating you well, if your employer is trying to change the terms of your employment, if you've been fired, if you've been let go and offered a severance package, or maybe if you haven't been offered any kind of severance and you have questions about your situation, this is your opportunity to get those questions answered by an expert in the field. I am an employment lawyer. This is the bread and butter of my work. It's what I do all day, every day, and I'm here for the next half an hour until 1:30 p.m., at least Eastern Standard Time, to answer your questions, help you resolve your workplace questions. So ask away, guys. Now is the opportunity. If you're dealing with a situation at work, if you're not sure about maybe how the COVID situation and maybe the vaccine situation affects you at work, if your employer is telling you one thing, you don't feel that's necessarily correct, ask away, guys. Really anything related to employment, I'm more than happy and also more than capable of answering. Wanted to start the today's live Q&A with a situation that came across my desk earlier this week, and a situation that's actually happening quite regularly now because of COVID, because of the impact on the economy. We're seeing lots of employers make changes to the terms of employment for their employees, whether that's a reduction in hours of work, or maybe it's a reduction in your pay, or maybe it's a change to your position or your job responsibilities. Something that's really happening more and more nowadays, it's becoming quite common in the workplace, are these kinds of changes. And we speak to lots of people that are going through exactly this kind of situation. And so I'd like to give some general tips, some general advice about what an employee can do when their employer sits them down for a virtual meeting and says, listen, moving forward, there are going to be some changes to your employment. You're only going to be able to work 20 hours a week, or you're going from 5 days a week to 4 days, or we're changing your position from a supervisor to a technical position. These are changes that are potentially what we call constructive dismissals. Now, what a constructive dismissal is effectively a breach of your terms of employment. In very simple terms, it's a breach of contract, meaning if you signed up for a job that's 5 days a week, 40 hours a week, and that's what you've been consistently doing for months or years of employment even, and your employer out of nowhere changes those terms, that may be viewed as a breach of contract, or again, what we call a constructive dismissal. An employer doesn't actually have the right, they don't have the legal authority to make a significant change to the terms of your employment without the employee's consent. And of course, if your employer is reducing your hours or reducing your pay, you don't have to consent to something like that as an employee. So what we advise people in these situations is, if your employer is reducing your pay or reducing your hours or demoting you from one role to another, and it's an obvious demotion, don't accept that change. That is step number one. Don't sign anything in the moment. Don't give your verbal consent in the moment. Say, I understand what the company is suggesting. I'm going to take a little bit of time to think about it and get back to you. So in that initial meeting, in that initial conversation, you want to buy yourself some time. Take whatever information your employer is giving you. Maybe it's a letter outlining the changes. Maybe it's just verbal. And oftentimes it is just verbal. Don't accept anything in the moment. Say, okay, thank you very much. I understand what you're saying. Let me think about it and get back to you. And what you want to do at that point in time is speak with an employment lawyer. Reach out to us, give us a call. We can review the situation with you. It's important to note, only a significant or substantial change to the terms of an employee's employment can be considered a constructive dismissal. And so if it's a very minor change, for example, if we're talking about hours of work, if your employer is only changing your hours of work by a couple of hours, maybe 2 hours or even 5 hours over the course of a 40-hour work week, that might be on the fence in terms of being a constructive dismissal. If it's a significant change, again, if it's 1 day out of 5 that you work, I mean, that's a 20% change to your hours and therefore your pay. That's definitely a significant change. So don't accept in the moment. Give us a call. Speak with an employment lawyer. There are a couple of different ways to reach us, and I'll get to the questions in a sec, guys. I'm starting to see them come through, which is excellent. Keep asking those questions. You can reach us if you have a question about changes to the terms of your employment. help@employmentlawyer.ca is the first point of contact where you can reach us. I guarantee you someone will get back to you if you email us at that email address. That's, again, help@employmentlawyer.ca. Send us a quick summary about your situation. Let us know what the changes are, what you're dealing with particularly. Give us an idea of how long you've been with the company, what your position is. We promise someone in our team will get back to you and will get you pointed in the right direction, either setting up a meeting with a lawyer or giving you perhaps a couple of different options in terms of the advice that you can get. But that's step number 1. Now, what constructive dismissals give you, if this is actually a situation for constructive dismissal, usually an employment lawyer can do one of 2 things for you. They can either get you out of that company, right, get you moving on to new employment and get you the proper severance that you're owed. Ultimately, that is what a constructive dismissal gets you. And again, we're talking about kind of a breach of contract here. If your employer breaches the contract and constructively dismisses you by changing the terms of employment, they owe you severance. That's what a constructive dismissal is. Now, in some other occasions, what we can actually do, and this might be the more desirable option sometimes, is actually get the company to back down and get them to not make those changes and keep you in your position. That might be actually the better outcome sometimes. So you've got a couple of options there in terms of resolutions. Either a constructive dismissal is going to give you severance and get you on your way to, hopefully bigger and better things when it comes to your employment, or we can force the company to back down and keep you employed in your current position based on your current terms of employment. Wanted to run through that, guys, because again, it's something that's coming up more and more often nowadays when it comes to COVID-19. Employers are obviously making changes to the terms of employment in response to changes in the economy, changes in business structures because of COVID. We're going to see lots and lots of this kind of stuff happening. It's already happening. And be wary of an employer making changes to the terms of your employment. Don't just accept. You have no obligation to accept those kinds of changes. Buy yourself some time during that initial meeting. Speak with one of our employment lawyers. We'll be able to properly advise you on your situation and hopefully help you resolve it moving forward. All right, let's get to the question, guys. We already got a few coming through, and that's what I love to see. Again, I'm not here to just chat generally about employment law, although I can do it all day, every day. I'm here to answer your questions and help out. So Dave, Razor, Donna, all of you that have asked questions, please keep it up. And all of you out there that are viewing, and maybe you're a little hesitant to ask a question, listen, don't be shy. There are no bad questions when it comes to employment law. Actually, chances are, if you're asking the question, chances are there are dozens, if not hundreds of other employees out there dealing with the exact same situation. So not only are you helping yourself by getting a question answered, you might be helping a ton of other people out there that have the exact same issue. So with all of that said, let's get to it. Donna asks, my employer has reduced my hours for the last 2 months, claiming it's due to COVID. Look at that. I mean, just exactly the situation I was just talking about. But other staff have still have the same hours. Is this considered a change too? It absolutely does. It is considered, of course, a change. I mean, it is a change, Donna. It's a question of degree. So again, going back to my examples, if your boss or your employer has changed your hours by a couple of hours here and there, and in the grand scheme of things, it represents maybe a 5 or maybe even 10% change to your compensation, I'd probably say, again, you're on the fence about having the legal protections of what we call a constructive dismissal. But if the reduction in hours is, again, anywhere over, I would say, a 10% threshold, and that's not an exact, it's not exact science. That's just a very rough estimate. But again, if it's, reducing your hours from 40 to 32 because it's, a 4-day week rather than a 5-day week, well, then we're talking about a significant change. And that is a problem Donna, the employer doesn't have the excuse of COVID in allowing for that change to your hours. That's not a good enough reason. Unless you've agreed to the change, Donna, you might have rights, you might have protections in the situation, and again, depending on the degree. So you need to reach out to us, Donna. Clearly, there is something up here. If other employees have kept their hours, but your hours are being reduced, and the reason the employer is getting is because of COVID, something doesn't seem right there. So you want to get advice. Again, help@employmentlawyer.ca is where to find us. Donna, send us a quick email, give us the basics of the situation, and again, I promise someone will get back to you. All right, Razor Sharp asks, how can I object to changes to my job without being terminated? Very easy, Razor Sharp. Politely, professionally, but sternly. So, don't feel pressured, don't feel bullied into accepting these kinds of changes. You can even say something like, listen, I understand where the company is coming from. I know it's not easy, but I just, I don't feel comfortable accepting this kind of change. That's really all it takes. Again, it doesn't have to be a kind of very heated, antagonistic, aggressive kind of conversation. You can very politely and professionally decline these kinds of changes. Now, maybe to the other part of your question, Razor Sharp, if your employer says, well, listen, if you're not going to accept this change, then we're letting you go, I have to say that legally, there's technically nothing wrong with that. Your employer does always have the right to terminate your employment as an employee. Think of it like any kind of personal relationship. Someone can always break up with the other partner in a relationship. You can't force that partner to stick around. They can break up just like your employer can break up with you, or vice versa. As an employee, you can break up with your employer. So we can't stop that from happening, Razor Sharp. If your employer terminates your employment, you can't necessarily fight the decision, but you will definitely be owed severance in a situation like that. And listen, severance is not just 1 or 2 weeks per year of service. Severance is going to be significant, especially if you've been with your employer for, a few years, and you're perhaps older rather than in your 20s or 30s. Your severance entitlements are going to be significant. They're going to be in the range of probably a month per year of service, if not more. Now, every case is fact specific, so we'd want to take a look at, very closely what your age is, what your position is, how long you've been with the company, what the job market looks like at the time that you were let go. But a termination is always possible in the private sector. If we're talking about unionized employees, it's a bit of a different ballpark. But in the non-unionized sector, your employer can always let you go. It becomes a question of how much severance you're owed. And if your employer is asking you to make detrimental changes to the terms of your employment, that's a problem. You might as well opt for the severance package. It's probably going to be the better outcome in the long term. All right, I see the questions flying in, guys. If I haven't gotten to your question and you asked it, 5 or 10 minutes ago, post it again. Guys, I want to see it again because I actually lost it on my screen here. So don't be shy to post your questions again if I haven't been answering. Janelle asks, not sure if this counts, but in regards to accepting changes, does that include workplace continuing to have people who aren't vaccinated to wear masks, even when mask mandates are lifted? That's a great, very obviously topical and relevant question, Janelle. This is going to be law that develops over the course of the next couple of months, especially when it comes to vaccines. So if we're talking about masks, Janelle, employers should still, and I think these are, just for clarity's sake, I am in Ontario, Canada. This is generally the case across Canada, but I'll talk specifically about Ontario because it's the province that I know. If you're somewhere else in the United States or anywhere else, I don't know what the local rules are. You will want to consult with your local public health officials. But in Ontario, health and safety in the workplace is always a priority. There is still mandatory mask wearing in workplaces, in public indoor spaces. So you have to be wearing masks, vaccinated or not vaccinated. That's going to remain the case. If your employer is not following public health guidelines, you're actually pointing in the right direction, Janelle. That may very well be a constructive dismissal, because if your workplace is not safe and your employer is not following health and safety protocols, that is potentially, and I would say likely, a breach of contract, which again is what a constructive dismissal is. So, short form lesson here, guys, is if your employer is not following public health and safety guidelines and either not telling employees to stay masked or is putting employees at risk, whether it's due to COVID or otherwise, number one, you want to draw those things to your employer's attention. You want to put the onus and the ball in their court to try and resolve those situations. If they don't resolve them, if they refuse to resolve them, you may be able to treat that health and safety issue as a constructive dismissal, as a breach of contract. Now, before you guys go out there and start claiming constructive dismissal to your employers, make sure you're getting legal advice from one of our employment lawyers first. Don't jump the gun. Speak with one of us first. We'll get you the proper advice that you need. We'll probably be able to kind of strategize with you guys and come up with a game plan as to how to resolve the situation. All right, Marina asks, I have applied to CPP disability because Sun Life asked me, they still the investigation. They asked me a few medical forms and I don't have anything else. Everything from my doctor, Sun Life has them. Do I need a lawyer at this point? Very good question, Marina. It's a question to do with disability insurance. Luckily enough, not only do I practice employment law in my practice, I also do some disability insurance work. I can answer your question, Marina. Yes, if Sun Life has asked you to apply for CPP disability benefits, you absolutely do have to apply. It is part of most, if not all, insurance policies when it comes to disability. If you've provided all of your doctor's information, Marina, to Sun Life, and they reject your claim and they deny you disability insurance, and it is clear from your doctor's records that you are disabled and unable to work, you should absolutely speak with us at this point. Again, help@employmentlawyer.ca is where you can reach us, even though I appreciate it's a disability question. You should absolutely reach out to one of us if the claim has been rejected. If you're still in that waiting period where you're not sure, they might approve your claim, they may not. Listen, wait for a decision. You can wait for Sun Life for a decision. But if you are told verbally over the phone from the adjuster, or if you are sent a letter, and this is usually how they do it, they send you a letter explaining why you've been denied, you should be on the phone with us immediately. Don't be shy to reach out. The initial consultation's free, Marina, so you're not going to have to pay a penny. And, let's get into this. Unfortunately, insurance companies will deny claims almost as a matter of course. Except for the most obvious of situations, insurance companies are very, very difficult when it comes to disability insurance. They will deny lots of claims illegitimately, and that's when you do need to get a lawyer involved. All right, guys, I wanted to go back to Dave, who asked the question that I missed. He asks, can an employer get out of paying statutory holidays? I was told because the construction company pays 10%, they are exempt from paying holidays. Interesting question, Dave. I guess the analysis becomes if you're receiving 10% kind of holiday pay, and it was clear from the get-go that that included statutory pay for statutory holidays, I imagine that 10% might actually cover, and it might actually be better than what you would get with just your kind of minimum vacation entitlements plus statutory holiday pay. So in other words, the 10% might actually leave you kind of further ahead when it comes to vacation and holiday pay as compared to just receiving the minimal amount of vacation pay, which is either 2 weeks or 3 weeks of pay, being 4% or 6%, plus those statutory holidays in Ontario, Canada, at least. Now, if your vacation, however, if, let's say your employment contract or your offer letter, if it just said you get 10% vacation pay, and it was very clear that it was just vacation pay and didn't include statutory holiday pay, you have an argument there, Dave, to say, well, no, that's my vacation pay. 10% is effectively, I guess it might be 5 weeks off. And so if you always understood that I have, 5 weeks of vacation pay in the bank every year, plus my statutory holiday pay, well, then you're right, Dave, you have a claim there. And what you can do in a situation like that, interestingly, and so listen, again, the point is you want to have a look at your offer letter or your employment contract. It might actually clear up the issue. If the 10% included within it statutory holiday pay, and that's explicit in the agreement, I think that's what it is. I think you're stuck with 10%, and that's the extent of it. If it's not clear, if the 10% is just with respect to vacation pay, then you will likely have a claim for statutory holiday pay. What I'd probably do in that situation, Dave, is contact the Ministry of Labor. The Ministry of Labor is not great when it comes to severance. They are not great when it comes to things like constructive dismissal, changes to the terms of your employment, temporary layoffs that are not legal. The Ministry of Labor can't help you with those things. They can help with overtime pay. They can help you with vacation pay or statutory holiday pay. So Dave, if you're having that issue, if you feel like you have a case there, don't be shy. Contact the Ministry of Labor. They will investigate and make a determination on the issue. All right. I think, Dave, you asked another question that I'll get to right now. If my company moves 39 kilometers and told me to quit or move, is this legal? They gave me time to decide. No severance was given. Great question, Dave. I'd say the answer depends. So certainly a 40-kilometer move is a pretty significant move, but it depends how much that actually impacts your employment. If that means that you now have to drive across the city an extra half hour to get to this new place of employment, and whereas before maybe your commute was half an hour and now it's an hour, you know what, Dave, that might be a significant change to the terms of your employment, and it might be a constructive dismissal. If, however, it doesn't really impact your drive into work, maybe it's a little closer, maybe it's the same distance, or maybe even it's slightly longer, but not significantly longer a commute, it's probably not going to be a constructive dismissal, in which case no severance would be owed to you. So the devil is going to be in the detail, Dave, and if you're not sure about the situation, I would say actually regardless, you need to get advice in a situation like that before you either resign or before you accept the change and the move. You need to speak with one of our employment lawyers. Again, help@employmentlawyer.ca is where to find this. Send us a blurb about your situation. We will respond to you pretty darn quickly, and I guarantee we will respond. Let's keep it moving, guys. I love the questions. We have about 8 minutes left here to get your workplace issues resolved. So please ask away. We're receiving a ton of questions daily about COVID-19, about temporary layoffs, about severance, about vaccinations in the workplace. That's been a really hot one the past few weeks. So by all means, ask away. Tamara asks, I work in an office doing customer care for a construction company. Builder not building much due to COVID. You were salaried before lockdown. Now you're 22 hours a week for the last 6 months. Found out someone else is doing your job. Do I have to accept this change in your job title and part-time work? I'm not certain whether I'm getting my old job title back. Great question, Tamara, and sounds like a difficult situation, obviously, again, because if someone else is doing the work that you were previously doing, that's quite unfair. It's, there's no reason why you are the one that should have been punished by having to accept part-time work simply because the company felt like it and because they ultimately decided that that might be better for them. So, Tamara, a change like that, going from a full-time employment to 22 hours a week, that is a constructive dismissal. That is a significant change to the terms of your employment. So you might have some options here in terms of recourse against the company. The issue that I might have to maybe give you kind of counter argument here is that if this is, if this has been happening for the past 6 months, enough time has gone by that you might be considered to have accepted the change. And so, if you would have reached out to us maybe a month into this change or even a couple of months into this change, I would have told you, listen, the timing is fine. You obviously didn't know you had these rights when this first happened. We're still early on enough that, we can still take action on this. But if it's been 6 months, Tamara, it makes it a tougher argument because your employer may be able to argue, and this is by no means a guarantee, it's a potential counter argument, they may be able to argue that by accepting this and working for 6 months in this part-time role, you've effectively accepted the change. Now, that's just a counter argument only. It doesn't mean definitively. And I see your comment. They tell you to keep waiting. Listen, I get it. I would suggest that you, again, very professionally, very politely tell them, I feel I've waited long enough now. I'd like to know exactly when I'm going back to my full-time hours, and I'm hoping that it's sooner rather than later. Draw that line in the sand, again, very professionally and amicably, saying, you're not going to be able to accept this for much longer. Blame it on your own personal finances, right? Blame it on, I simply can't afford to work part-time hours any longer. I need to go back to my regular terms of employment. You probably want to reach out to us, Tamara, and have a chat and discuss strategy. I'd want to have a look at a few things. And listen, I'm assuming here you're in Ontario, Canada, or alternatively, we have offices in Vancouver and offices in Calgary as well. So if you're in Alberta or British Columbia, you could speak with one of our lawyers in those offices. But we probably want to have a chat. I'd like, perhaps to review your employment agreement and see if that affects things, and see if, there's anything else there that might help your case or not. It's important to review the documentation when it comes to every single case. Hopefully that helps. All right, Lori asks, are employers allowed to force non-vaccinated employees to wear masks, but vaccinated employees do not have to? Lori, if you are talking about employers in Ontario, Canada, and I think this is the case across Canada in general, but don't quote me on that. No, there's no distinction at this point in time with respect to mask wearing and vaccinated versus unvaccinated employees. Again, specifically in Ontario, whether you are vaccinated or not, if you are working in an indoor office environment that is, that has, more than a few employees probably, or perhaps even just 2 employees, you have to wear a mask in that workspace. So you have to wear a mask either way. If that's not the case, your employer may be running afoul of local public health and safety guidelines. Don't be shy. Don't be shy to put these kinds of questions to your employer. Your employer has a positive obligation to maintain public health and safety in the workplace. They have to take action when it comes to these kinds of issues. They cannot just brush them off. If there is a health and safety incident in the workplace, they have to investigate. They have to come to a decision, and they have to protect employees' health and safety in the workplace. And if they're not, again, don't be shy to reach out to an employment lawyer. Don't be shy to even reach out to the Ministry of Labor about a situation like that. That's perfectly reasonable to do. All right, guys, the last couple of questions. Alex gets in under the line here with a couple of minutes to go. Alex asks, you work for a roofing company. I'm a W-2 employee, commission pay only after my job is built. I have 30 days contacts with home owners that are 60 days late because of production office. Now I'm losing contracts because of this. Is this legal? Interesting question, Alex. I think what it likely comes down to, if I'm understanding the question correctly, is, listen, if it's out of your employer's hands as to when these contracts are being finalized or not. So if it ultimately has to do with a production office being late, and whatever the reason is, maybe it's a question of supplies not being readily available, or a lack of staff, or something along those lines. If it's not necessarily the employer choosing to delay these things, you can't blame the lack in commissions on your employer. It's simply a question of whatever it may be, maybe the particular industry or the economy at the time, or a supply chain, etc. That's going to be tough to really enforce on the employer, because again, it's not necessarily up to them whether the contracts are complete or not. Now, if it's the employer's fault, and maybe they're even doing it purposely to delay these contracts, to maybe avoid some of these obligations to pay employees, well, that's obviously a problem. So if it's in the employer's power to get these contracts done and get you paid, and they're just choosing not to do so, Alex, that is a problem. You can probably enforce your rights in that respect. So it's a question of, again, whether the employer has that control or not over the project. If it's, even partially unrelated to their control over finalizing the project, you're going to have a tough time convincing anyone that you should get paid for that reason. All right, guys, we're going to wrap it up at that point in time. Again, any other questions, any other concerns? There are absolutely no obligations here, guys. We are not going to charge you to ask a question at help@employmentlawyer.ca. Feel free to send in your questions there. A couple of other resources that you can use as well, and we've got a ton of resources on our website. It's employmentlawyer.ca. Very easy website, obviously, to just plug into your phone and search employmentlawyer.ca. We have blog articles, news articles, videos, audios, you name it. We've got a ton of resources there about really anything and everything under the sun when it comes to employment law. So don't be shy to visit our website. We've obviously got our contact information there as well. We have our list of various offices, various lawyers, etc., etc. We'll leave it there for this afternoon, guys. I think we've got another live show coming on Friday. Tune in then and ask your questions. Thank you all very much for watching. It's been another edition of Employment Law Q&A. Again, my name is Alex Lucifero. We will catch you next time. Until then, enjoy the rest of your week and all the best.